The Companies Act 1956. Section 9. Act to override memorandum, articles, etc. The Act to override memorandum means the Companies Act 1956 to override memorandum, the Companies Act 1956 to override articles. Section 9 of the Companies Act 1956. Save as otherwise expressly provided in the Act. Save as otherwise expressly provided in the Act. The provisions of this Act shall have effect notwithstanding anything to the contrary contained in the memorandum, notwithstanding anything contained in the articles of a company, notwithstanding anything contained in any agreement executed by it, notwithstanding anything contained in any resolution passed by the company in general meeting or by its board of directors, whether the same be registered, whether the same be executed, whether the same be passed, as a case may be, before or after the commencement of this Act. This is clause A of section 9. Let us go to clause B of section 9. Here, any provision contained in the memorandum, any provision contained in articles, any provision contained in any agreement, any provision contained in any resolution aforesaid, to the extent which it is repugnant to the provisions of this Act, become or be void, as the case may be. From these provisions of section 9, we may understand the Act can override any points, any provisions of the memorandum, any provisions of articles of association, anything of any agreement. The Act also may override any provisions, any points of resolution passed in general meeting or board of directors meeting. If at all any points are repugnant to the provisions of this Act, such provisions will become void, as the case may be. From section 9 of the Companies Act 1956, this is what we may understand. It may be very interesting to read this section 9 in the Companies Act 1956, listening that the Act is going to override memorandum of a company. The Act is going to override the articles of association. The Act is going to override the agreements. The Act is going to override the resolutions passed in general meeting or passed by its board of directors meeting. Is this provision essential for us? Is this provision unavoidable? Yes, it is felt inevitable to have this provision. This provision is crucial. This provision also very critical. It is realized and inserted in the Act. Imagine, in the absence of this provision, how things would have gone havoc. there would have been complete chaos on having articles of association as per the wishes of the promoters, as per the wishes of the directors of a company, which focus on their vested interests. The companies would have entered into agreements ignoring the provisions of the Act, ignoring the contemporary laws, in the name of association or articles of association, agreements entered and registered, containing the provisions which are inconsistent with the Act. The very purpose of the Act would have turned useless. The very purpose of the Act would have turned ineffective. The very purpose of the Act would have turned worthless, hollow. You may be understanding why this section plays very important role by its provisions. The provisions of Section 9 of the Companies Act 1956 is vital for the implementation of the provisions of the Companies Act 1956. After this commencement of the Companies Act 1956, no company may have the provisions inconsistent with the Act in their memorandum, in their articles of association, or agreements, or resolutions, or in any process. We may ask ourselves, what about in the case of companies incorporated under the previous companies laws? Yes, for that, the provisions which were inconsistent, the very provisions turned void to the extent they were repugnant to or irreconcilable with the provisions of the Act. There may be some case laws, where we may also try to understand the provisions of or the importance of the provisions of Section 9. There are some cases very popular which you all are aware. Case law Amrut Kaur Puri versus Kapurthala Flour, Oil and General Mills Company Limited 1984. Here an article of a private company providing for a larger quorum than prescribed was held valid. Again, case law Amrut Kaur Puri versus Kapurthala Flour, Oil and General Mills Company Private Limited 1984. Here an article of a private company providing for a larger quorum than that prescribed was held to be valid. What is actually the quorum required in case of private company? Here, what is the prescribed quorum? We are all aware. We find this in section 174 subsection 1. As per this, the private company may have a quorum of 2 members personally present. Let us have complete reading of section 174, quorum for meeting. Unless the articles of a company provide for a larger quorum number, 5 members personally present in the case of a public company and 2 members personally present in the case of any other company shall be the quorum for a meeting of the company. The case law which we refer just now, that is Amrut Kaur Puri versus Kapurthala Flour, Oil and General Company Private Limited 1984. Here the large quorum than 5 persons was provided. That is, in the case of a private company that you are all aware. It was held to be valid. Actually, what was required? Only two members personally present. In the case of any other company means private company. If the provisions of the Articles of Association of certain company are more stringent, are more tough, are more stern than what is prescribed in the Act. Good question. We all need to understand in such a situation it is held that such provisions are also valid, where the Act provides for sanction by general meeting, by ordinary resolution, and the articles of a company provide for special resolution. What happens? No doubt, the articles of the company will prevail. The articles of the company will prevail. They will be valid. Similar articles will not be treated as void. Now, may we go to another case law? Here, case law is Mihir Hemant Moffatlal versus Moffatlal Industries Limited 1987. This is a bit different case law. The Articles of Association carry a provision depriving the company of its powers to increase capital. It was held void. It refers to Section 94. Section 94 of the Companies Act 1956, power of limited company to alter its share capital. Subsection 1 of Section 94. A limited company having a share capital may, if so authorized by its articles, alter the conditions of its memorandum as follows. That is to say, it may increase its share capital by such amount as it thinks expedient by issuing new shares. Whereas, in the case law we referred, Mihir Hemant Moffatlal versus Moffatlal Industries Limited 1987, the Articles of Association carry a provision depriving the company of its powers to increase capital. It was held void. This is another case law. Let us go to another case law. Oriental Metal Processing Works Limited versus Bhaskar Kasinath Thakur 1961. Here in this case, it is held that a provision in the Articles of Association empowering the managing director to appoint any person underlined. Empowering the managing director to appoint any person to be the managing director by will is treated as valid. We may ask, what about the provisions of Section 312? Let us refer what Section 312 carries. Section 312 of the Companies Act 1956, prohibition of assignment of office by director. Any assignment of his office made after the commencement of this act by any director of a company shall be void. Underline, shall be void. Any assignment shall be void. Any assignment of his office made after the commencement of this act by any director of a company shall be void. Here you might have noted expressions any assignment, another shall be void, any assignment. Whereas in the case law what we refer, what is there? Is it an assignment or is it an appointment? Yes, you are right. In the case law we refer, we come across an expression, an appointment. Whereas in the provisions of Section 312 we noted any assignment. That is the difference. It is held that we are given to understand that the provisions of section 312 speaks of assignment, underline. The provisions of section 312 speaks of assignment and not appointment. So as it is here in this case law, it is an appointment, so it is held as valid, concluded that it is not an assignment. So like this, in this case law, Oriental Metal Processing Works Limited versus Bhaskar Kasinath Thakur 1961, things are like this. Till now, we are discussing about the provisions of Articles of Association, Memorandum, Agreement, Resolution of a company which contravene with the Act. What about if they contravene with any other laws, contemporary laws? Let us have one more case law. A limited company is required to maintain its books of accounts on mercantile basis as per section 209 of the Companies Act 1956. As per section 145 of the Income Tax Act 1961, income chargeable under the head profits and gains of business or profession or income from other sources shall be computed in accordance with either cash or mercantile system of accounting regularly employed by the assessee. If a company maintaining books of account as per Companies Act 1956 determine its income for income tax purposes on cash basis, underline. If a company maintaining books of account as per Companies Act 1956 and determine its income for income tax purposes on cash basis, in doing so, will the assessee violate the provisions of section 145 of the Income Tax Act 1961? Let us understand. Section 209 prescribes, Section 209 of the Companies Act 1956 prescribes the books of accounts to be kept by a company. Proper books of accounts shall not be deemed to be kept in the following occasions. Books not kept in such a manner to give a true and fair view of the state of affairs of the company or branch office. Books not kept on accrual basis and according to double entry system of accounting. Whereas when we go to section 145 of the Income Tax Act 1961, it deals with the method of accounting. Income chargeable under the head profits and gains of business or profession or income from other sources shall be computed in accordance with either cash basis or mercantile system of accounting regularly employed by the assessee. Also, where the assessing officer is not satisfied about the correctness or completeness of the accounts of the assessee, or where the method of accounting employed or the accounting standards have not been regular or consistent, he may make an assessment in the manner provided in section 144. As per specific provisions of section 145, a right to choose the method of accounting is given to the assessee. Thus, an assessee can prepare its accounts either on mercantile basis or cash system of accounting for income tax purposes. The right so given cannot be taken away by the assessing officer by applying the provisions of section 209 of the Companies Act 1956 as a provision of another enactment cannot override a specific provision of Income Tax Act. Refer to the decision of Chennai Finance Company Limited versus ACIT 81, Hyderabad. In the said decision, it is clearly held that the provisions of company law cannot override a specific provision of the Income Tax Act 1961, like section 145 of the Income Tax Act 1961. Here, the situation would be different. If there is no specific provisions under the Income Tax Act 1961, then one will have to go by the provisions of the Companies Act 1956 for the selection of the method of accounting. However, when there is a specific provision under the Income Tax Act 1961, the Honorable ITAT was of the view that the said provision cannot be overruled by the provisions of the Companies Act 1956. When we are referring Section 9 of the Companies Act 1956, the Act overrides the Memorandum of a company, the Act overrides the Articles of Association of a company, the Act overrides the points of any agreement of a company or resolution. Here, this case law what we refer is bit different, and we may also call totally different. Whereas we are comparing two acts, one the Companies Act 1956 and another is the Income Tax Act 1956. It is given to understand that the provisions of the Companies Act 1956 may not override the provisions of Income Tax Act 1961, which is clear from its point of view. Again, let us go to Section 9 of the Companies Act 1956. Section 9, Act to override Memorandum, the Act to override the Articles of Association, the Act to override any agreement or resolution. Let us refresh again. Save as otherwise expressly provided in the Act. Save as otherwise expressly provided in the Act, the provisions of this Act shall have effect. The provisions of this Act shall have effect, notwithstanding anything to the contrary contained in the memorandum. The provisions of this Act shall have effect, notwithstanding anything contrary contained in the articles of a company, or in any agreement executed by it, or in any resolution passed by the company in general meeting or by its board of directors, whether the same be registered or executed or passed, as the case may be, before or after the commencement of this Act. Any provision contained in the memorandum, articles, or agreement or resolution aforesaid shall, to the extent to which it is repugnant to the provisions of this Act, become or be void, as the case may be. Yes, at the end of this discussion, it is clear to all of us the Act, the Companies Act 1956, the provisions of the Companies Act 1956 will override the memorandum, will override the articles, will override the agreement, will override the resolution. The Act to override memorandum, articles. Section 9 of the Companies Act 1956. Thank you.